I'm speaking with Commissioner J.C. Moore. We're talking about treatment court options, and we do have a seminar coming up in a week and a half, and that is Innovations in Justice, Treatment Court Standards, and Competency Cases, and that is happening on Friday, March 14th. So the first question that I kind of have for you is you really did lead the charge on putting this program together, and I know that it's clearly something that you're really passionate about. And I was wondering if you could tell us why. Like, what was the catalyst for making this such an important topic for you?
First off, Jesse, thanks for taking the time to talk to me about it. I'm really excited for this training. I've been involved in treatment courts for, probably about 25 years now. I've been practicing law since the early 90s, and I was a public defender for a good 20 years before I became a court commissioner. And so I went through the 90s with the war on drugs, and I saw clients over and over again who might have been caught with some marijuana, some cocaine once, twice, and had significant addiction issues. And again and again, I saw them going to prison for longer and longer periods of time. And I started to think there's got to be a better way to do this, as opposed to just seeing my clients who have significant addiction issues that they just can't beat go to prison, spend time in prison, and come back and not getting any help for any of their issues. So I started to do some looking into treatment courts. And treatment courts have been around for a long time. The very first one was in Miami-Dade County in 1989. Wisconsin had their first treatment court in 1996. So the model was out there. It was just a matter of latching onto it. We were able to roll out our first treatment court in Milwaukee County late, admittedly, in 2009. I helped with that some, and then we started to set up other different types of treatment courts that were all based on the same model. There are a lot of different variants out there that kind of address specific needs of the individual, whether it's drug or mental health. They try and address specific needs of the offense type. We set up our adult drug court in 2009. We set up our veterans court in 2012. I'm particularly proud of my involvement in that one. And in Milwaukee now we have 5 different treatment courts, and there are a variety of these across the state. Wisconsin has over 100 treatment courts across the state. They kind of run the gamut in terms of the specific types, but they are all based on that same model that dates back to 1989. And I've been involved in them for a long time now. And so when I saw the opportunity to partner with the state bar and the Wisconsin Association of Treatment Court Professionals, which I've served on the board for a long time, I jumped at it because it's something that government lawyers need to know about.
Is there something like misconceptions you think that people have about treatment courts? And do you think maybe that's perhaps why it's not quite as widely used as it could be?
I think there are a couple of different things. First off, I agree with you. I think there are some misconceptions about it. I think the first misconception that you hear about is that it's soft on crime because it's an alternative to someone going to prison or going to jail for a lengthy period of time. And my response to that is that it is not soft on crime. It is smart on crime because it addresses the fundamental issues which cause the individual to be involved in the criminal justice system to begin with. You can lock someone up in prison or in jail, but at the end of the day, they're going to come back out into the community. And if you're not dealing with those core causes of why they were involved in the criminal justice system to begin with, then you're just going to have the same types of offenses. And the thing about treatment courts is they go through a very specific deliberative process to figure out what those needs are and address them, and also have a pretty strong, pretty robust supervision that takes place. I mean, if you practice in the criminal justice system, you know that there are really 3 different outcomes to any case. There's either probation, jail time, or prison. And in virtually all 3 of those things, there's some sort of supervision that goes on where you're being supervised by a probation or an extended supervision agent, and you have rules that you have to follow. And a lot of my clients used to say that they'd rather just do their 30 days in jail or go on regular probation because it was easy as opposed to going through the treatment court where you got to face a judge every week who is checking up on you. You have a number of different treatment providers that you are working with in order to provide services. You have a probation agent who is looking at you very intensely. You have a member of law enforcement who you're seeing on a regular basis. So it is extremely intense. It is not easy at all. And by utilizing that process, as I said, you get to the issues that cause the criminal involvement to begin with, and you do away with them. And I mean, the outcomes that you get are just incredible. I've seen people reunited with family, get back into their career, become productive members of the community, deal with their particular issues. I mean, people just turn their lives around when they're involved in this. So once again, it's not soft on crime. It is smart on crime. And I mean, it's effective too. It is one of the most closely examined programs that is out there. They have these things called 10 key components. It's kind of the 10 things that make a treatment court a treatment court. Well, one of those is collecting data and using that data in order to change the program and make it more effective. And that's been done over and over again on the national level by generating national standards on treatment courts, on the state level by generating state treatment court standards, and even on the local level because programs collect this data, look at it, and manipulate their programs or change their programs in order to make them more effective. And the outcome is that they are more effective than prison or probation or jail, and the data proves it. That's why I'm just so excited about those programs in general, and why I'm so excited to be able to bring it to the people that are going to be logging into this webinar.
How do you see treatment courts evolving over the next decade? And are there any components that you would like to see improved upon or changed?
That is a timely question because when treatment courts first came about, especially in Wisconsin, mid 90s, pushing 2000, they were kind of popping up here and there. I mean, they were almost kind of grassroots, if you will. And then in 2007, there was something that happened that changed it, that caused the number of courts in Wisconsin to just explode. And that's called the TAD program. It's Treatment Alternatives and Diversion. And it's essentially a funding program by the legislature where individual counties can apply for grants in order to set up or enhance treatment court programs. And there's, of course, underlying legislation for them saying that the program has to look this particular way. It has to use best practices. It has to be effective. And we're going to look at how effective it is. And assuming that, then you have this money that's available in order for you to help set up and enhance the program. And that's what really caused this explosion of courts across the state. As I said, now we've got over 100 courts across the state in virtually every single county. I think there are only about a half dozen counties that don't have at least one kind of treatment court in it. And then, number one, I don't see the TAD funding process going away because it's been so incredibly successful. Number two, if you look at the governor's budget, he has a provision in there that dramatically expands upon the TAD program and also allows for a process where it's administered by the director of state courts provision. The money goes directly to the counties, and so if those provisions get passed, or if something similar is passed, then that will just serve to increase the number of courts that we have across the state. Plus, I think there is a lot of leadership that has been being demonstrated both by the Department of Justice and also with the Director of State Courts Office and other statewide programs to really try and develop and improve upon existing standards that are out there to make sure that everyone knows what the best practice is for these programs. On the national level, there were just um, best practice standards that were put out by an organization called All Rise, which does training for virtually every treatment court across the United States, and there are literally thousands. The Wisconsin Association of Treatment Courts is going to be putting out their own next version of treatment court standards, building upon what All Rise said. So I think that over the next decade, you are going to, number one, continue to see expansion of these courts just because they make sense, because they are, in many instances, more cost effective for cash strapped counties that aren't, have reduced resources in terms of jail or prison. And I think there are a lot of people out there that are working in order to make sure that with these courts comes the right standards, so that we know that the courts are operating the right way and that they are they're doing good, as opposed to just kind of winging it.
Do you have any recommendations for counsel who are trying to convince their clients to choose the treatment court option versus going to jail or probation?
The best way that counsel can impress upon them the importance of participating in these programs, and I'm not trying to suggest that it will always be the right answer. Um, Programs that are out there have certain standards where if you're committing certain types of offenses, you're not going to be eligible for it. If you are displaying behavior that is over a certain level of risk, you might not be eligible for it. So, I mean, there are going to be limitations. It's not a program for everyone, but if it applies to your particular client, then definitely you should understand the program, because it's clearly a viable alternative. And it will, I think, ultimately inure to the benefit of your client. And maybe you'll get a response like, no, I don't want to do it. It's too difficult. It's not for me. And of course, that's a decision for the client to make. But one of the best ways to express the importance of the program is, number one, to understand the program itself. And in your particular county, you can figure that out by going to the court coordinator for your county. All of these courts have someone called a court coordinator, and that coordinator is responsible for taking all of the reports from that team of experts that's on the treatment court team and putting it together and reporting back to the judge and organizing things. And that coordinator is going to be the one who understands the program best. So if you need more information about your particular program, reach out to that coordinator, and I am sure they'll be able to educate you. On a broader level, if you just want to educate yourself in treatment courts generally, just so you have that kind of background understanding, then this is a great resource. And there are other training opportunities out there that you can take advantage of. There's an upcoming conference that WATCP has, and there are a lot of different conference and training opportunities that you can partake in.
Commissioner, thank you so much for speaking with me, and I hope you have a great day.
Thank you, Jesse. I appreciate it.